Document. For pronouncement of judgment, item 28.
For the conclusions drawn by us, we do not find any infirmity with the decision of the learned single judge. Writ appeal stands dismissed.
Item 39.
The learned single judge's decision is not interfered with.
Adjournment request.
May I please, Lord? Item 21 to 23. In these cases, earlier we took time for filing affidavit. Affidavit is ready, but we require some more time to file it. I'm praying for 3 weeks time to file it.
Last time you said government
Yes,
is considering
instructions
something.
come, affidavit is also ready, my lord, instructions. We have sent it for
We are
waiting.
contemplating some, the grievances to redress the grievances.
So that the lordship mentioned, we have mentioned everything. The affidavit has been sent for waiting, so it is ready, my lord, to file. 3 weeks time.
How much time?
3 weeks. In the meantime, we'll file it.
Okay, at the request of the learned council for the state. The matter is adjourned for 3 weeks.
Right.
May I please, your lordship? Well, let's fresh admission, but item 14, my lord. May kindly be adjourned for day only.
1/4.
14, 1/4. Only for day, my lord. My senior AK Purga has some problem today, my lord. That is only for day.
What is the problem?
Is some problem, my lord. AK Purga is the sir.
Passionate appointment after 18 years. Can't give.
Only for today, my lord.
Movie will do it. कोई दूसरा नहीं यहाँ पे item number 16.
That's all for the day.
Yes.
Hello, may I please? Item number 16 is wrongly listed before this honorable court. It is pertaining to a single bench, my lord.
Item number
16.
16, what?
It is wrongly listed, my lord.
How? It is before you have challenged the policy.
Policy.
Other cases are, my lord, before this single bench, my lord.
You have challenged the office memorandum.
Yes, that's why my office executive instruction. It is before
That the policy of the state government of compassionate appointment.
Yes, it is fixed. Other series of cases are fixed tomorrow, my lord.
Appropriate bench.
May I claim, my lord? My lord, item number 19, my lord. In this case, my lord, client, my lord, consulting with the senior advocate, my lord, to view to engage, my lord.
Huh?
So, my lord, the client, my lord, is trying to engage some senior advocate, my lord. The consultation is going on, my lord, after 2 weeks, my lord.
You are quite senior, sir.
I'm not saying, my lord.
We can't, we expressed our reservation last occasion. We can't put a blanket ban on issuance of the caste certificates.
My lord,
In
it is
case
the-
where if you find that this caste certificating is wrong, you can very well challenge it.
my lord, it is the client, my lord. I am, my lord, conveying their desire.
Okay, then
Okay.
fine, then one
Yes,
line.
thank you.
इन्होंने टाइम लिया था
On 7/3/2025, after hearing,
Building another senior. Only.
earlier, Mr. Narjiri, senior advocate.
My lord, he is, my lord, not well, my lord, hospitalized for 1 week, my lord.
Okay, on 7/3/2025, this court, after hearing the learned concept of the petitioners at length, has expressed its reservation in granting the relief prayed for in this PIL petition. Full stop. Learned concept of the petitioners takes some time to and at that stage, learned concept of the petitioners takes some time to complete the instructions. Today, learned concept Mr. So and so has submitted that the petitioners wants to have to engage some senior counsel because the senior counsel, learned senior counsel appeared on 7/3/2025 is hospitalized. When?
Well, after 2 weeks, my lord.
Just after 4 weeks,
May it please, Your Lord.
as prayed by the learned. Yes,
May it please, Your Lord. Lordship, I beg to mention item 28. I'm mentioning on behalf of respondent 13 and 14, Your Lordship. Here, the conducting counsel, his wife is in the hospital, Your Lordship. So this matter may be adjourned for 2 weeks, Your Lord. We have taken consent from all the parties.
बट इसी इशू में सर एक इशू पेंडिंग है यहाँ पे petition नंबर 3 नहीं दे सकते हैं बट उसको अमेंड करके उन्होंने हमारे इनको वेट कर दिया उसी को
yes, who is appearing for the petition?
I'm paying for a petition.
Do you have it?
No.
Is this PIL petition at the request of the land council appearing for the respondent number 13 and 14? The PIL petition is adjourned for
2 weeks, Your
4 weeks.
Lord. Deeply over.
Yes,
My lord, I seek your lordship's leave to withdraw item number 36.
36.
This is income tax appeal, my lord.
Yeah, yeah.
And the appellant has opted for Vivad Se Vishwas scheme. So we have to file this order.
Counsel for the petitioner on instructions has submitted that he wants to withdraw this appeal since the SSC has opted for Vivad Se Samadhan.
Vivad Se Vishwas.
Vivad Se
Vishwas.
Vishwas scheme
Vivad Se Vishwas scheme 2024.
2024. Dismiss as withdrawn.
May I please, Your Lordship, I beg to mention item number 33 of the daily list. Can it be taken after 4 weeks, Lordship?
After
4 weeks.
4 weeks,
Lordship, the other side has not appeared and we have to seek some instruction from the department.
service is complete. Hearing mein laga hai. Other side, so we have already proceeded ex parte against them since nobody has appeared despite service.
Lordship, some accommodation is required. Can it be taken up?
4 weeks. Ka?
2 weeks, Lordship.
Adjourned 4 weeks.
Much obliged, Lordship.
Yes, I will counsel with the appellant 4 weeks.
32. 32. 33.
Yes,
Lordship, with the consent of the other side, I beg to mention item number 37, Your Lordship.
adjourned
Obliged, Lordship.
8 weeks.
Any other request?
Eight weeks. Yes,
For orders, item 1.
My lord, on behalf of Council D. Kogoi, I'm seeking a passover for the day, my lord. He had some difficulty, which is
to simply show us whether there is any provision to take some action against the erring contractor who has admittedly excavated the mineral beyond the that mine lease
As per my instruction, a draft rule is being prepared, Lordship. It is going to be.
Prepared नहीं है, बोलो, क्या किया है, that is the
सब होगा कल होगा
the request of the concept of the respondent is this petition of review.
नाम तो ठीक है
Public.
item 2
In this case, state has filed an affidavit.
Yes, sir, on 16/2.
My lord, in the affidavit file, they have stated that some progress has been made. So that detailed reports are yet to come up. If the lordship would kindly come to their affidavit at page 191,
Yes,
paragraph 3.
yes.
That this instant additional affidavit has been filed in the compliance of the order dated 18/12/24, passed by the honorable court to bring on record the status of the work undertaken by so and so, a consultancy service agency engaged by Guwahati Metropolitan Development Authority for preparation of GIS-based comprehensive drainage master plan and detailed report for Guwahati City along with exception report dated so and so, submitted by the said consultancy agency. In regard to the same, it is hereby submitted that the work for preparation of GIS-based comprehensive drainage master plan detailed report is in progress. Currently, work related to topographical survey and detailed inventory of the existing stormwater drain for preparation of master plan in consultation with all concerned departments and preparation of the detailed project report for Bahini River sub-basin is in progress. Further, a revised inception report was submitted by consultant on 26/12/24 and the same has been circulated to the stakeholder for the views and comments. So, my lord, let this progress, my lord. But there are certain suggestions, my lord, which my lord would like to place, my lord. They may consider, my lord. In fact, it has been given by, my lord, the former CEO of the Guwahati Metropolitan Development Authority. Now, these are some of the measures which they have suggested, my lord. So I have placed it on record. For example, my lord, building permission for all new construction for those low-lying areas which needs to be filled up for construction may be put on hold for a period of 3 years, all till flood problem of Guwahati is eased. All hill cutting, well, this is one area which I think, my lord, something should be done. All hill cutting should be banned in Greater Guwahati for a period of 3 years or till all the hill slopes are stabilized to structural or through natural vegetation. All reserve forests within Greater Guwahati should be made encroachment free and massive plantation drives should be taken up by the forest department. All non-Miyadi Patta lands should be surveyed properly and no big structure should be allowed in those lands. The occupants of those lands should be barred from changing the land contour of those lands in any form and not to fill up those lands with soil from outside area. Critical project. The surface runoff from Assam Meghalaya border area of Pasarkusi to Balughat channel is entering into the city through cross drain construction by NHI near Tripura Road. This stormwater is discharged through stormwater drain and is outfall at Bahini channel at Beltola, and where the Bahini channel water level increases even with rain in Meghalaya hills. Therefore, Rukmini Gaon area gets inundated. It is required to divert the stormwater towards Vasishta channel from the existing NHCI drain on southern side to be reconstructed with proper gradient. The NHCI has to, well, these are some of the suggestions, my lord.
Yes, yes.
I hope, my lord, they will take note of all this. But that is an aspect, my lord, hill cutting. That is an aspect, my lord.
Yes.
I think the authorities should address, my lord. Let them proceed with the plan, my lord. These are some of the suggestions. I think these are
They
worth
already-
considering.
In their, this affidavit also, they have said in views and comments for circulated for views and comments.
Yes.
Regarding all these things definitely will come to our consideration. If Lordship passes an order with a specific instruction, what is our stand on hill cutting, then it will be beneficial for us also. regarding hill cutting. We have tried lot of things, but if there is further monitoring of this honorable court, that will be easier for us. I appreciate that.
My lord, it is an aspect we cannot altogether discount as is required for development work. But they can identify a particular areas instead of
Yeah.
rampantly doing everywhere.
These suggestions, it is the 3 years or so and so.
Yes.
So the government may consider it 3 year or 1 year or 2 year or whatever it may be. If it
My
is,
lord, nowadays, when we land at Guwahati airport, earlier the hill in front of the airport used to be green. Now lots of people see half of them is red. After that, of course, a portion of it is in Meghalaya also. It's not that entire thing is in Assam.
in fact, the problem in Guwahati is also there, but the neighboring state problem on account of that also we are.
In fact, my lord, this flood problem is partly Meghalaya's responsibility because entire
there
water
is
now
no
comes
check.
down here.
There is no check about this.
And the art cutting is more rampant in Meghalaya. I think if it is regulated, my lord, to a large extent, this can be solved.
It can be for the time being. Be careful. Pursuant to the direction given by this court on 2024. An affidavit is filed on behalf of the Government of Assam, Department of Housing and Urban Affairs, through its secretary, wherein it is stated that work for preparation of GI-based comprehensive drainage master plan and detailed report is in progress. Full stop. Currently, work related to the topographical survey and detailed inventory of the existing storm water drain for preparation of master plan in consultation with the concerned department and preparation for detailed project report for the Bahini River sub-basin is in progress. It is further stated that a revised inception report was submitted by the consultant on 26/12/2024 and the same has been circulated to all the stakeholders for views and comments. Stop. Mr. K. N. Chaudhary, Learned Senior Counsel, Amicus Curiae, I submitted that some of the suggestions have been offered by what was this?
He was formerly, my lord, Chief Executive Officer of DMDA. He's an retired IS officer.
By a retired IAS officer who has worked as Chief Executive of the Guwahati Municipal
No, Guwahati Metropolitan Development Authority.
Guwahati Metropolitan Development Authority. So, the said suggestions are placed on record by Mr. K. N. Chaudhary and the same are taken on record. The copy of the said suggestion and views is also supplied to Learned Advocate General. Full stop. It is in those suggestions mainly some concern. Mainly it is suggested that the building permissions, hill cutting permissions be not issued for a period of at least 3 years or till for a period of 3 years or till effective steps are being taken to tackle the flood problem in Guwahati is eased. It is also suggested that reserved forests within Greater Guwahati should be made encroachment free and a survey be conducted in respect of the non-Miadi pattas and no big structure should be allowed in those lands. Full stop. It is also it is highlighted by Mr. Chaudhary and Mr. Sekia that hill cutting is a great problem in the hill cutting is one of the reason for flood problem in the Guwahati. It is contended that though the land is required for the construction, etc., but the hill cutting, rampant hill cutting is to be checked and stopped. Full stop. We hope that all the suggestions and views offered by the by an officer who was the chief executive officer of the GMDA shall be taken into consideration by the state government objectively while preparing the master plan as suggested in the affidavit, in the latest affidavit. Full stop. At the same time, we request Mr. Sekia to place on record the measures taken by the state government, the measures which are adopted by the state government to tackle the hill cutting problem in the greater Guwahati.
Guwahati and its surrounding areas.
Guwahati and its surrounding areas in the state of Assam.
Lot.
When
In the state of Assam. Yes, Lord, so we know 131 is their article.
when
One part is Meghalaya part, the other part is Chandrapur part. And nowadays, earth is not, hill earth is not taken for filling up of land, low-lying lands. For that, the river silt of Brahmaputra is sufficient. The hills are being cut to develop the area for constructions. That is the problem. That is the issue now.
where this is going.
Now the hill earth is not used for majorly for this earth filling low-lying areas.
It is mainly for the purpose of construction.
Construction.
So when you
2 or 3 weeks time may be given in the
4 weeks will grant.
Lords.
It will be 4 weeks.
Lords.
Let's start with 4 weeks. On that day, the latest spectral report be filed by the state of Assam.
One is landscaping, the other one is that construction.
Yes. that is there.
Highly applied for it.
Deep problem.
ये बिल्डिंग परमिशंस जो है ना पहले शुरू में किया था बिल्डिंग परमिशंस इन द लो लाइंग एरियाज जो फर्स्ट एक
Item 3.
Wait, the lordship. As per
two of
last
the
one-
respondents,
Yes, my lord. I have-
respondent number 4, I
Yes, my lord. We have taken.
4 and 6.
Yes, my lord. we have-
I'm appearing on behalf of the board, pollution.
For 4.
Yeah.
And who is appearing for 6? Chairman Municipal Board Halakandi.
I appear
Miss-
for respondent number 5. Filed in.
On last occasion,
No, no, it for an account.
Chairman municipal board.
No.
Yes.
Notice the bullet.
Dilute already loaded. Already loaded.
Service complete.
No, terminal complete.
Serve the check.
Oh, no, sub police. Then
6 is the Chairman Municipal Board Halakandi.
Service complete.
5 and 6 are getting out. Who is appearing? You are for respondent number 5.
5.
What the deputy commissioner is doing?
Look, the stand of the deputy commissioner is reflected in paragraphs 7, 8, and 6, 7, and 8
Of
of the counter affidavit.
your affidavit is there?
Yes, we filed it on
Yeah.
5, 9, 20.
What is your stand? What is your stand?
Well, this is government land. It's protected by a boundary wall. And the waste, Malad, it's mainly paper and perishable items, Malad, paragraph 8 of our lord, of page 57 of your lordships.
So you are using it as a dumping ground.
yes.
Yes, Malad.
The dumping ground in the residential area.
Well, at page 18 of my petition, my lord. Exact scenario is there, page 18 of the petition.
And it is away, my lord. It is not next door, as they say, at least 4 or 5 kilometers away, my lord.
Densely populated area, what they are claiming.
My lord, I have
This
objection in
plot
this.
belongs to whom?
Government, my lord. The land,
Government.
yes, my lord.
But at least
There is a
these,
boundary wall, my lord.
management, this waste management rules in the act clearly provided that it should not be in the residential areas.
Exactly.
Locate some other land for that.
About 30, 40 years back, my lord, it was started. Now it is densely populated, schools, hospitals, everything nearby.
You have to rethink over it.
My lord, originally it was barren, my lord. Now there's encroachment. They've
So
come.
now you have to shift somewhere else, man. You can't, if people are residing there, then you have to shift it over. So council,
Yes.
they denied this, that it is a densely populated area or this veterinary sub-center is there in para number 14 of their affidavit.
Yes, my lord. We have the objection of this, my lord. In the meantime, I will file the objection, my lord. I have the
Write
record.
the objection and place some material.
Yes,
Place
immediately.
some material on the.
By next, within a day, maybe given, my lord. In the meantime, I will produce, my lord.
Like, as per the office report, notices issued to the respondent number 4 and 6 have not been served till date. However, Mr. So-and-so is appearing on behalf of the respondent number 4. Let notices issued to the respondent number 6 be awaited for 3 more weeks. In the meantime, the counsel for the respondent number 5 may apprise this court that whether the respondent, whether the administration is identifying any other land in the process of identifying any other land to be used as a dumping yard for the waste of the Alakandi town, waste generated from the Alakandi town. To stop. The learned counsel for the petitioner is also granted time to file affidavit in opposition, counter affidavit to the affidavit in opposition filed on behalf of the respondent number 5. Just after 4 weeks. As per the office report, 4 and 6, not each other. However, Mr. Soto is appearing on behalf of the respondent. Stop. Since, Ismail Itana, since the notice issued to the respondent number 6 is awaited from long time, the concept of the petitioner is directed to take fresh steps for service of notice upon the respondent number 6 through Dusty mode within a period of 1 week on filing of the same. On taking such steps, that notices, fresh notices be issued to the respondent number 6 to Dusty mode returnable 4 weeks. उसके आगे ये जो
Obliged.
Item 4.
Please, your lordship. Lordship, as per office note dated 3rd March 2025, lordship. Notice upon respondent number 5 has been completed, lordship. However, respondent number 6, neither AD card nor unserved notice has been received back, Lordship.
Government. नहीं तो हमारे खातों recruitment of नौकरी ना एक दुकान मैंने ठीक nothing. Photo get restored. Who is respondent number 6?
President,
Lordship, may I submit? My lord, I'm appearing for the respondent number 5. He is the head priest of the temple.
Yes.
And 6, Lordship, again, they are the same. 6 is the president of the committee of priests. So he has authorized the respondent number 5. So
You are appearing on
so Wakalatnama I have not filed. I have only filed for the respondent number 5, but the respondent number 5 has been authorized. So my presence, Lordship, may record for 5 and 6.
In the meantime, you filed the Wakalatnama also. What's the problem?
I'll file.
Okay, as per the office report, the notice issued to the respondent number 6. I will still await Mr. So-and-so, the consul appearing for the respondent number 5 has submitted that he is also appearing for the respondent number 6.
Lordship.
Will file power on behalf of respondent number 6 within a period of 1 week.
Lordship. I'll
Within a
do.
period of 1 week. And what is this in this PIL?
Lord,
2013, the already PIL is entertained and the order has been passed. Now what remains? Till the decree of the court is there, who is going to touch that? Until and unless the decree is reversed or modified.
Lordship, I'll satisfy the court on the
Not
next date,
right now.
Lordship.
When?
Lordship, any date as per your Lordship's convention.
You have to argue, please take a date of your convenience. Today also it is inconvenient for us to hear the matter.
Lordship, in the first week of April, Lordship.
Speak over.
Lordship. In fact, the earlier PIL was filed by an NGO and that was represented by the petitioner here only.
This PIL petition for admission in the first week of April as prayed by the counsel for the petitioner.
And in the
Much
meantime, liberty may be granted to file affidavit.
It is there.
Lordship.
Nobody has prevented you.
My lord.
File.
Much obliged. Lordship.
Obliged, lord.
Item 5,
No, please, your lordships. My lord, the IA that has been filed for substitution of legal heirs, that is not on record. Due to a defect, it was this in the filing section, it has been stuck. The defect has been cleared now.
So
So the matter may be adjourned for today and the record may be called for, the IA may be called for.
What relief we can grant you now?
My lord, my petition was
Relief. So now I think you are around 55 years of age.
55, my lord.
And now we are seeking appointment.
At least a notional appointment, if not, at least.
What notional appointment?
My lord, I have been fighting since 2010.
Uh,
And this
though if you have been
litigation
fighting
got,
since 2010.
this got pending only due to the delay on the part of the respondents, my lord.
93 ka advertisement. Many of the persons have already retired. Some
Few
of them
expired.
died.
My lord.
What remains in this petition? Why you are, let this petition be decided? Why you are giving false hope to the petitioner, this appellant?
My lord, I have explained, but
Yes, the case is pending, he'll die in this weight of the decision of the case. Why to keep the false hopes alive of the person?
but my lord, the appellant was in the litigation.
Genuinely you feel we can issue an order for appointment of the.
Appointment at this stage may not be possible. No, it's not possible.
Then
But may
what
not,
will
it is
be,
not
sir?
possible. But at least
If
a
he will
notional.
not be able to get the appointment, what remains?
But he had challenged the appointments of the
Of
rest-
those persons
of
who
those
are working
persons.
from last 2 decades or 3 decades.
But he came before the court on time. And
Yeah, whatever it may be, but now what?
that is his grievance. He says that I have come on time.
This is what we say, खाएंगे नहीं तो गिरा देंगे. वो
Not
बात
like the
है,
bylaws.
जिनको मिला हुआ है उसका गिरा देंगे.
So, my lord,
उनको तो नहीं मिलेगा.
the ground on which they were appointed, that is not correct, my lord. I'll obtain instruction. I'll try to explain. And just one date may be fixed.
It is noticed that on the last, on 29/11/2024, this court has granted time to the counsel for the applicant to bring on record the legal representatives of respondent number 13. However, the same, IA for, however, IA for bringing the legal representatives of the, however, as per the office report, the IA for bringing the legal representative of the respondent number 13 has not been filed till date. Learned counsel for the applicant has submitted that he has already filed an that the IA for taking on the legal representatives of the respondent number 13 on record is already cleared, is already ready for, is already registered after curing the defects. And therefore the office be directed to place the same on record. Full stop. Having gone through the controversy involved in this case, we are of the view that the matter can be heard even without taking the legal representatives of the respondent number 13 on record. List this IA along with the writ appeal number 15932 of the 2023 filing number for admission along with the IA so preferred on behalf of the applicant for admission on Monday.
Monday. Obliged, madam.
Item 6.
There is a
Right.
Objection file করিব objection file হোক নহলে মোৰ কিন্তু বেয়া আছে ল'ব কাৰণে
EPF, EPF. Sir,
my lord
stand before the learned single judge
my lord
was that the basic grievance of the petitioner is only against the Airport Authority of India,
no my lord
page number 61
my lord
of the
actually
writ appeal.
actually my lord, in this case appellant has engaged some outstation lawyers my lord I have been requested to make it
Outstation lawyer for this.
yes my lord.
The petitioner is basically agreed with the Airport Authority of India. Simply you have said, "Hamara koi lena dena nahi hai." The Airport Authority is agreed by the action of the Airport Authority.
No, my lord, actually,
The court has granted.
no, my lord, in this case, we cannot discontinue the EPF pension, my lord.
You,
There is no,
you have discontinued with the EPS pension in respect of some of the employees pursuant to the Madras High Court judgment.
no, my lord, there is a, in CCS pension rule, my lord, if someone avails the
You
EPF
can't-
pension, they are
you
not
can't deny
entitled
the
to,
benefit. You can't deny the benefit once he has,
No.
he is ready to pay whatever you have paid to him. Can't do
my lord, there is no provision in
So
EPF.
there is no such provision, sir. There is no such averment in your reply to the before the learned single judge that we can't discontinue this. There is no such averment. Rather, you have admitted the case of this respondent.
My lord, let it be taken up 1st of April, my lord, as they have requested, my lord.
The 211 days. Looking to the nature of controversy involved in this petition. Yeah, involved in this case. We propose to hear the connected rate appeal number 16001 of 2023 along with this IA for condonation of delay. Learned counsel for the applicant has submitted that some outstation counsel is supposed to argue the matter. Also, he prayed for listing this IA along with the connected rate appeal on
On 1/4, my lord, 1st of
1/4.
April. Deeply obliged.
Ask them
Yes, yes,
to prepare on ready to argue on merits.
yes, ma'am.
Item 7.
My lord, this appeal we would like to withdraw, my lord. With the liberty to, with either will
What
file the,
Liberty, what liberty?
my lord, liberty has already been granted by the learned single judge to file a fresh writ petition, or we will approach the civil court.
Whatever it may. देना चाहिए। Only the appellate authority, the learned single judge said that this notice was issued pursuant to the order passed in the appeal.
Yes.
What is the illegality in that? That appellate authority so far. Then as such the instant appeal, however, the court categorically observed the dismissal shall not cause any prejudice to the assail the order in accordance with law. That's all.
Lordship.
Wants to, then concept of the applicant has submitted that. The, as on instructions has submitted that the applicant does not want to press this IA. So, in view of the above, this IA is dismissed as not pressed. Consequently, the connected rate appeal number so and so is also dismissed.
Much obliged.
Item 8.
May I please, Lordship? My lord, all the respondents are represented. I think my friend will express for urgency. Let the matter be fixed for hearing, Lordship.
Not
hearing, admission. Yes, that can be.
Okay, Mr. So and so put an appearance, it is noticed that all the respondents are represented through consents. Through respective consents. Is this matter
Next Monday, my lord.
on so and so date?
Next Monday, my lord, because urgency is there.
Take the date.
Yes.
I'm not interim order that way. There is an
Because
interim.
they have come,
Interim order,
stipulation
if any
file
to
against the
continue
interim
till
order.
Next date.
Yes.
Interim order, if any to continue till next date.
Item 9.
Yeah. So, content. Notice. Never 4 weeks.
Item 10.
General man. Yes,
Page 6 is the order, lords.
yeah.
And page 9 is the representation. It was filed on 16/9/2024.
But he has already clarified that this railway people that we are ready to construct. Let us give the fund in the writ petition itself. Their stand was this.
Sorry, lordship, I can't get.
The railway stand before the writ court in the PIL that they are ready to construct the RUB. Let us give us some fund from the state government. Let us provide some fund for from the state government. This was their stand in the PIL,
Yes,
was their stand.
but issue is that fund is ready. But Railway Development Authority, Railway Authority did not approach the state government to disperse the fund, and it was not reflected in the order itself. So the learned court granted me liberty to file representation. Accordingly, I have filed.
Goes for orders.
Lordship?
Yeah.
Sorry,
Close for orders.
Lordship.
Item 11.
Yes.
Item 12.
The I is filed for condonation of delay of 796 days. My lord, we have preferred for independent writ petition, a writ appeal, my lord, against common order. And some of in some cases, my lord, the delay has been condoned, my lord.
Your lordship has already directed to issue notice in some cases.
Already delay condoned, my lord.
Delay condoned.
Yes, my
In
lord.
some cases, delay has been condoned, but in
And-
some cases, notice has been given again.
But if in some of the matters delay, I think cannot.
Yes,
And-
that's true.
And 4 cases are admitted, my lord. Appeal is admitted. They are admitted.
Some have been admitted.
Yes, my lord.
Where is that admission order? Then it concept of the applicant has submitted that various appeals have been preferred against the impugned judgment by the Union of India. And in those appeals, this court was pleased to condone the delay and has also admitted admitted the matters. Full stop. Learned counsel appearing for the respondent is not in position to dispute the above. Hence, the delay of 796 days in filing the connected rate appeal is condoned. IA number so and so is allowed. The connected rate appeal is admitted after its registration by the be treated as admitted after its registration by the registry. No need to issue formal notice to the respondents who are represented to the concept. List this writ appeal along with writ appeal number 50/2025.
Obliged, my lord.
For admission, item 13.
Well, the similar appeal lordship has already admitted. Writ appeal number 381 of 2024. My friend is appearing in that case also. Here also he appears.
Here appeal.
Lordship.
Well, what is the next date in those appeals?
Writ appeal number 381 of 2024.
Next date.
Date is not been given, my lord.
And what about the work?
Well, there are 5 works, my lord, and at that point of time, my lord, there was a status quo order, but by this time,
70% of the work was complete.
at that point of time, it was complete. Then status quo order was passed.
Status quo order where?
No, status quo order in the writ petition, my lord. After display, after stay here, my lord, possibly by this time it's complete. I have to take the instruction, my lord.
Instructions.
I'll
It is
take.
complete then.
No, lord. I have to take the instruction.
Mr. So-and-so put in appearance on behalf of the sole respondent, on behalf of the respondent number 1.
Yes, my lord.
What about other respondents?
Other respondent, they have also filed appeal, my lord. I'll give copy, my lord.
Respondent number 1, I am receiving.
The other respondents, it is stated by the counsel for the petitioner that the other respondents in this writ appeal has also preferred appeals against the impugned judgment. So, learned counsel for the petitioner, appellant is at liberty to serve the copy of this writ appeal to the concept for the other respondents who respective counsel of the other respondents who are appearing in the writ appeals wherein the impugned judgment is challenged by them. Full stop. List this writ appeal along with
Writ appeal number 381,
381/2024. 2024.
Okay,
Lordship.
may I pay one thing, lordship? Lordship, still this lordship status quo as on today shall be maintained by the respondent, lordship, because they will otherwise, if lordship state this matter, they will complete the work order, lordship.
Let
It
them
will-
complete.
It will lordship become infrastructure otherwise.
Judgment,
Companies 70-80%.
No, lordship, it was not done 70%, lordship.
The learned single they observed in.
Lordship, it is the fact that, lordship, the fact is that, lordship, despite passing the status quo order by the Lionel trial court, the respondent has released the lordship bill. First thing. Second thing, lordship, no, lordship, I am just,
That
I
is
am
not
the,
that is not the scope of
no,
this.
that is why, lordship,
already lordship has passed an interim order.
status quo as on today, that must lordship be recorded, otherwise, lordship, they will complete.
No,
the work.
already there is an interim order, my lord.
Interim order that will go, lordship, because in this case, this petitioner has not selected.
Lordship has already passed an interim order in the appeal.
Interim order, other appeal definition, lordship, petitioner are different. And in this case, lordship, petitioner is
Interim
different.
order, if any, to continue till next.
Lordship. Obliged.
There is no such interim
No,
order.
no, my lord, here, my lord, I have
Yes,
three. In the other appeals, lordship has already passed the.
Without hearing us, lordship, without hearing us.
Yes, expert.
That
yes,
is, that
so
is why,
can't
lordship, because taking that advantage, lordship, they will complete the work, lordship. That is the problem, lordship.
even though if we can pass the order expert.
That's true, lordship has
We
prerogative,
have
lordship.
passed it, sir.
Lordship. But in this case, lordship, since I am here, lordship, at least, lordship,
Okay, argue it out for stay. Argue it.
lordship will fix in next Monday, lordship.
Today it is.
Today, lordship, yes,
We should only.
lordship.
Sir, in similar matters, if you have already passed an order, propriety demands we should pass an order.
Lordship, thing is that, lordship has passed the stay order without hearing me, lordship. Because in this case, lordship, since I am appearing, lordship, otherwise, if lordship stayed.
Writ appeal 381,
Stay the
order
order,
dated
single
21
bench,
to
lordship,
25.
they will complete the work, lordship, because they are, lordship, doing all this arbitrarily, lordship. Despite the honorable court order, stay order, they have, how can they release the bill, lordship?
Council, if in the similar appeals, if we have passed the stay orders, why will not pass the stay order in this appeal, sir?
Lordship, the status quo regarding the impugned work order, lordship, status quo may be maintained, lordship. Let the lordship order of Lionel single be stayed. In the meantime, lordship, status quo may be maintained regarding the impugned work order.
Twenty 25/11 order to labor is writ appeal 381. Ulia di bote yaar. Koi de, kam kulia bote. Koi de. 381. 25/11 order to labor.
The status quo is there also. Regarding.
Status quo will.
Malad on 25,
Create multiple supersede.
2511, 381. Malad, it's a, in common appeals, Malad, it was passed.
Not by this petitioner lordship. Common, not by this petitioner lordship. This petitioner different lordship.
No.
Because there are-
State is the appellant. State is the appellant.
State is the appellant lordship. The thing is that lordship, there are five writ petition, 6 writ petition filed lordship.
All the petitions were allowed.
2511,
Yes, all
25.
the petition. Now if,
And in 5 writ appeals,
yes,
we have already stayed there.
lordship.
Order to forward.
Lordship, it will trigger this petition, nothing will happen lordship. It will become infrastructure on the part of this petition only.
क्या लिखा है? Along with so and so. At this stage, learned counsel for the appellant has submitted that in the writ appeals referred against the impugned judgment, this court has already passed an order staying the effect and operation of the impugned judgment. Full stop. Learned counsel appearing for the respondent has opposed the request for interim order and has submitted that those interim orders were passed ex parte and therefore the no interim order be passed in this petition and at the most status quo order be passed. Full stop. Having heard the learned counsel for the parties and after taking into consideration that in writ appeals challenging the impugned judgment, this court has already passed an stay order staying the effect and operation of the order passed by the learned single judge. The propriety demands that in this writ appeal also the similar stay order is passed. Hence, the effect and operation of the impugned order dated 29/7/2024 passed by the learned single judge in writ petition number
1069 of 2024.
1069/2024 shall remain in state.
Item 15.
Also, as per last order, they were supposed to supply copies of OA, reply, rejoinder, and other vital documents.
Yes.
They have not filed anything in the meantime, Lordship.
You filed
Then I'll file comprehensive affidavit in opposition, Lordship, enclosing everything.
OA and this other relevant documents.
Yes, I'll along with my reply to the writ petition in a comprehensive manner.
This after 4 weeks.
Obliged.
Item 17.
Lordship, I have given an instruction, Lordship.
What instruction? Whether you adopted?
Lordship, there is already a notification in this regard, gazette notification of 2010, wherein until and unless some exception are made by the council, the normal state action rules are automatically adopted, Lordship.
My lord, that is prior to creation of the BTC, my lord. That my notification, my lord, meaning thereby, my lord, if existing law is there, it will be applicable. But when this newly law is passed, they have to adopt. মোটা দিয়েছেন এখন হচ্ছে না
This, in 2010, Bodoland Autonomous Council, Territorial Council is already there.
My lord, this Bodoland Autonomous Council was created in 2003, my lord. So this is, my lord, they have said that whatever it is still that, my lord, that is applicable.
Huh?
It is after, my lord, 2025, they have to adopt it. Last, my lord.
2010 notification is already there.
Yes, but
Public notice.
2010 means, but till 2010, whatever law is applicable in the state of Assam, without any amendment, they will apply in the BTC.
Fine.
But after 2010, they have to make the notification, my lord.
This is service rules 2023, you mean to say that?
My lord.
File your affidavit.
Yes.
Consider. Okay. Mr. Peter, in concept. For BTC has submitted that. Pursuant to the notification dated 20 of October 2010 by the Principal Secretary, Board Land Territorial Council. The rules, the Assam Land Records and Subordinate Service Rules 2023 are also applicable in the area of the BTC. Stop. Learned Council, Mr. Sharma, Mr. Chaudhary plays some time to file affidavit of this effect in counter to the writ petition. Time plate for his response. How much time?
Lordship, 3 weeks.
4 weeks.
For a status quo,
Start
my
with
lord.
4 weeks. Status quo.
My lord, they have selected, let them, my lord, they remain as it is, my lord.
Sir, application of law can't be stayed.
My lord,
Very exceptional circumstance.
my lord. But they have made selection, my lord.
Let them,
Let them, my lord, status quo, my lord, till returnable that they may not proceed, my lord. So that,
we'll pass an order.
my lord.
Item 18.
Mr. Majumdar.
We have filed our affidavit, my lord. The parking is being done there. As of now, because of the stay order, there is no parking done now. Otherwise, my lord, the deputy commissioner and the Tezpur Municipal Board have to sort it out. Because the agreement
Standing
was
counsel for the Department of.
that we have filed, my lord.
You are,
We have filed on 28 to 2024. I filed my affidavit.
what affidavit you have filed?
My lord, that was by the inspector of school. Very from page 33 onwards, my lord, in my
Yes.
at page 38, my lord. This is the order by the chairman. This is the request by the chairman to the principal of the school
Request for utilizing vacant land for Tezpur Assembly School.
for temporary parking.
Then
Then, my lord, on 26/5 on the next page, the SMDC of the school gives a no objection for temporary use.
fine.
Thereafter, my lord, on the inspector of school receives a representation on 6th of November 2023.
Yes,
That was forwarded to the Deputy Commissioner to interview, my lord, on page 42, 9/11/2023.
then
My lord, the Deputy Commissioner now has to, Deputy Commissioner and the Tezpur Municipal Board, my lord, they need to shift it some other place.
this is the school, government school.
My lord, yes, it's a government school. But the Deputy Commissioner, my lord, perhaps has. Land
Listen
lessons
to the subjects, I have the honor to forward the copy of the memorandum. You have written this letter to whom?
To the Deputy Commissioner, my lord.
And who is appearing for the deputy commissioner? You are appearing.
Yes, Lordship.
What happened after this 9/11/2023 order?
Lordship, lastly, I have not received any communication, Lordship. I shall get it within week, Lordship, next week, Lordship.
A reply is, a counter to the writ petition is filed on behalf of the inspector of school, SDC Tejpur, wherein it is stated that the inspector of schools has already written a letter to the district commissioner Sonitpur, Tejpur on 9/11/2023 with a prayer to revoke the decision of
Yes, provide.
क्या लिखा है? Tejpur, whereby it has forwarded the representation received from the petitioner, petitioner number 4 and others, alumni of alumni of Tejpur Academy Higher Secondary School, wherein they have prayed to revoke the decision of using playground for Tejpur Academy HS School for parking. It is stated by the concept of the petitioner that till date, no response. Till date, the district commissioner Sonitpur Tejpur has not responded to the said request of the inspector of schools. Learned counsel appearing for the district commissioner Sonitpur Tejpur is directed to file comments on the above petition by the next date of hearing, placed on Wednesday, next Wednesday.
Next week, Lordship.
26.
Complete your instructions in this day.
Wednesday, Lordship. 21, Lordship.
Wednesday, next Wednesday, whatever the date.
26 March. Item 20.
Lordship, in this case, I am supposed to file an affidavit. I have received the paper. We'll be filing it tomorrow, Lordship. Can it be taken up on Friday or next Monday, Lordship?
इसका नाम ही नहीं है, शायद इसमें होगा, इस जगह पे होगा इसके अंदर, लेकिन एलिजिबल नहीं है। बाकी लिस्ट में कहीं भी इसका नाम नहीं है।
Okay, Mr. Chakravarti placed some time to, submitted that he is going to file counter to the writ appeal by tomorrow. List up to 4 weeks, list up to 10 days.
My lord,
If you want to file any counter, file it.
my lord. Deep your lordship.
Item 24.
May it please your lordship, my lord. My lord, here, my lord, the respondents supposed to file affidavit, they take 2 times, my lord, for filing, they have not filed. Now, my lord, this matter relates to, my lord, under the scheme of Agnibi, the petitioner was engaged. My lord, he met with some accident during the, my lord, training, and the training, that accident treatment period has been treated as missing, my lord. So matter will be fixed for hearing on a particular date, my lord. Page 42, my lord. He was admitted by the, yes,
Yes.
sorry. Inke Goswami asking. But however, my lord, there is a scheme, my lord, that leave includes, my lord, annual leave, 30 days sick leave. Sick leave based on medical advice. I was on leave, my lord, 30 days on the advice of the doctor, my lord.
Missing training,
Yes,
missing training, page 83.
that's correct. Yes, my lord. 80, yes. But,
What, but
my lord,
missing training,
yes,
admission in hospital including attend see bed rest.
my lord.
Following absence period will be included.
But this is not as per the scheme, my lord.
Whatever it may be.
No, no, no.
No.
My lord, there are so many judgments, my lord. There in the tribunal itself, there are some judgments saying that since as per the scheme of the Agnikot, my lord, leave includes sick leave. So sick leave on the advice of the doctor, that cannot be treated as, my lord, missing.
Sir, here policy detention for additional training and release of Agni during training period. This policy was very much there.
I will place those judgments, my lord. Lordship may hear on a particular date, my lord.
Which date?
As per convenience, my lord, no problem.
You have to argue, we are convening
Yes,
today,
yes.
today also.
And the judgments, my lord, I suppose they will file affidavit,
We are
Yes.
convening today also.
my lord. On 29th, my lord,
29.
Oblas.
29th of
April, go dilu. Hobo.
Saturday.
Oh, sorry. My lord, then, my lord, immediately after Bihu, my lord, 29th of April, my lord.
At the request of the council for the teacher, just on 29th of April.
My lord, Oblas.
Item 25.
May it please your lordship. First of all, I am sorry, your lordship. I am apologize before this honorable court, as last 2-3 days I was not able to appear before this honorable court due to my ill health, your lordship. And there is a direction of this honorable court on 9/4/2024 for filing an affidavit. And today, your lordship, I have filed it, but it has not come on record. So your lordship, can you fix this matter on 21st of this month? ফাইল কৰি আছে নিয়ন্ত্ৰণ।
Petitioner present in person, they submitted that. She has filed an affidavit as directed by this court on earlier occasions. Today itself,
Yes, your lordship.
today itself. The registry is directed to place the same on the record and let this petition after 3 weeks.
Oblige, your lordship.
Item 26.
Lordship, in this matter, petitioner is on lag in court number 2, your lordship. FZ Majumdar, your lordship.
Pass over for the day,
For today.
pass over for the time being.
Oh, time limit.
Yeah.
For
Time being.
oblige.
Item 27.
The matter pertaining to victim compensation scheme. Now, Lordship, the matter pertaining to victim compensation, Lordship, can you see the last order,
May I
8
pray, my lord, before
2020?
my learned can start, my lord.
Yeah.
My lord, on the last occasion, an instruction is sought for from the government, my lord.
What
My,
about the mechanism for February
My lord,
2024
may-
का आगे का?
may I pray, my lord, for some time for
25 का भी तो डिमांड पड़ा है ना?
25 for,
No, no. Mr. Sharma, learned counsel advocate is director to clarify regarding the plan of the government to tackle the claim which may arise within the financial year.
my lord,
35.
for which, my lord, some short time may kindly be granted.
Lordship, second aspect of the matter, my lord.
Because some discussions has been held between the secretary from the department, secretary.
What about the remaining amount of 10 crore?
My lord, there are some discussion which held, my lord,
Discussion
between the
discussion
regarding the amount, my lord, there are some
there
disputes.
is no scope of
my lord,
negotiation उसको कम ज्यादा करने का
no, but there are some disputes, my lord. Disputes is, my lord, the requirement was, my lord, 27 crore or something. As per, my lord, Asal sir,
You have verified it many times. It was 44 crore and it was verified. They have already furnished all the documents. Now you can't say that it's less amount is there and nothing else.
for which, my lord, some document, there was some telephonic conversation
Well,
between
it's
my
the
the home
legal
department.
services authority has
My lord,
done
lordship
it.
may
It is
kindly
not an
fix,
individual's case.
day after tomorrow, I will, my lord, clarify this.
Lordship, second aspect of matter, in terms of the scheme 2012, my lord, closely says that each year the budget has to be allocated for this victim compensation scheme. Now, Lordship, this current year, how much amount they have earmarked, my lord? That has to be clarified, my lord. alone.
Is there?
That point, my lord.
That will be clarified, my lord.
In fact, the tentative proposal for the year 25 already been sent.
While taking into consideration, we have asked them.
That specification, my lord.
Mr. Sharma, waits a short time to complete his instruction in respect of the observations made by made by this board on 10/2/2025. Yes,
Next week, my lord.
it's on Monday.
My lord.
One point, may kindly clarify about how much amount they have earmarked in this current year?
Yeah.
That has already been reflected in the earlier order.
Well, they are
I'll
doing
take
nothing,
it
my
back,
lord. Because of the pressure, they are releasing the amount. Otherwise, my lord.
Oblige.
Item 29.
Marks that we marked with the candidate at school. There was a.
Pardon, Lordship.
There was the candidate of the mark there. There was an indication which page.
Yes. Nine, no?
Yes.
Wait. Written date, page 54.
It's
77. Nine to what? Not, maybe to the 4
only.
ফোন নম্বর এডমিট কার্ড নম্বর কেন কিবা হ'ব
Itu agent pada ada
Lordship.
Earlier that Meghalaya gentleman, maybe
D. Shira.
Shira. Shira was the highest mark. He scored higher.
He was appointed as a general candidate.
He was appointed as a general candidate. But unfortunately, you had shown him as a ST candidate. In that point, he was holding a ST point. So the panel was wrongly prepared. Now, in the present panel, there is one SC candidate. He has scored the second highest marks. Why was he not accommodated as a general category candidate?
No, Lordship Paris, that is something admit card number of Paris other number.
No, that is the marks.
Lordship relying page 59.
Page 55. Come to page 55. Total number. Total number. What is this T number?
Lordship Paris, that maybe something.
Mr. Sharma,
else,
what is this
Lordship.
T number? What is your marks in this selection?
Lordship, my instruction is that Lordship, this is not a mark.
This is not the marks. Oh.
Not the mark.
Yes.
Where is the marks?
Marks is not available, Lordship.
That I can produce, Lordship. I can take instruction, Lordship.
Marks over
Panel is
That promote that cannot follow second.
How was the merit list prepared?
But definitely on marks basis, Lordship.
Where?
That I have to produce, Lordship. Lordship
So you mean to say Shira did not get the highest marks there? Got the highest marks there?
in 2015,
15.
maybe. I have to
Where
take
is that
instruction.
document that he was?
Lordship, that I can ask for them.
No, here on record.
Here on record, nothing is there.
We just want to find out that the person who is secured, this SC person has secured more marks or in comparison to the general candidates, why is not been adjusted against
Lordship,
the
exactly,
general-
Lordship.
general
But
vacancy?
perhaps that is not marks. I can take instruction to that regard, Lordship.
Otherwise, Mr. Consul, these, if they found later on, whatever they stand before the cat, that some inadvertently this ST seat was left. What's wrong in that? They can do it.
Lordship,
That doesn't mean that once they have decided to.
I'm not saying that, Lordship. I'm not saying that. But Lordship, on the last occasion also, I had made one submission that it is okay. A reserved candidate, he can participate with unreserved candidates, and if he secures better mark, and he can be accommodated against general. But Lordship, there is an exception to that, Lordship. If he secures better marks, if he is qualified on own merit, but with some relaxation and concession.
That's right.
With some relaxation and concession, then lordship, he cannot be accommodated among the
Against the unreserved seat.
against the unreserved seat.
Yeah, that-
Here, lordship, they have been granted pre-promotional training. Lordship, I could have understood, lordship, if the relaxation concession was in the form of something which has no connection with marks. Suppose age relaxation or fee relaxation. But here, lordship, the relaxation in the form of pre-promotional training has direct bearing on the marks. The training was given prior to the. So it is also a form of concession and relaxation.
Marks.
And also that Shira's selection.
Chakravarti placed the time to place on record the marks obtained by the candidates in selection in question. Based on
After 3 weeks, because 2015, that has also need to be slightly.
3 weeks.
Oblige.
Oblige.
Item 32.
In this case, lordship, we have filed 2 affidavits. The second one is fully consolidated, lordship. Whether they would like to file a response or not, we do not know, lord.
No, my lord. My lord, we are today for the hearing of the matter, my lord.
Hearing,
Hearing.
we need some time.
My lord, time is.
We need some time.
My lord.
We need some time to go through the affidavit.
My lord, only our concern is that, my lord, as there is no, although a separate legislation has been enacted, but there is no rule has been, my lord, till date notified. As a whole, my lord, the entire community, my lord, in the state of Assam is suffering, my lord. And my lord, the another thing is that, my lord, the law is, my lordship, from my very limited knowledge, what I beg to submit, my lord, the law is well settled that the government can make any law, that power is there. But my lord, while making this law, what they have done, they have interfered with the religion. They have no, my lord, I will. My lord.
If they have interfered with the religion,
My lord.
there is a violation of Article 25. 13.
Exactly, my lord. And the religion has been fully defined, my lord, by in the, my lord, recent judgment of the Sayara Banu as well as in the Sabrimala's case also, my lord. So we will rely on those judgments, my lord. If my lord is not inclined to hear today, my lord, a short date may kindly be given.
We are inclined to hear today, but we have to go through it. It's
Exactly,
not a matter
exactly.
of, it's a simple matter.
My lord, my lord.
Validity of the law is under challenge.
Exactly, my lord.
Consider it requires some lengthy hearing.
My lord, my lord.
We have also have to prepare ourselves for that, sir.
My lord.
Yeah.
My lord can fix for final hearing and disposal, my lord.
You have filed 2 affidavits.
Yes, lordship. Initially, that was not fully. I'm sorry, lordship. In fact, we had one small one, but we did not file. Finally, we filed a consolidated one, lordship.
You are going to file.
No, we have already filed. It is with them.
My lord, we have a copy we have received, my lord.
Consolidated.
Mr. D. Secretary, concept appearing for the state has submitted that. He has already filed a consolidated affidavit in writ petition number.
My lord, and 6428 of 2024.
6428 of this 2024 period. The strength of the state is clarified. It is submitted that the said affidavit will cover all the other 3. Will cover all the will cover or will be treated as an affidavit to all the other writ petition in all connected writ petitions. Full stop. Since the validity of the
Lord, the
state
Assam
act is under challenge, it requires a lengthy hearing. Hence, admit list for the hearing in when.
A date may kindly be given, my lord.
Sometime in the month of May, lordship.
Lord, it will be very late, my lord. Last part of before the vacation, my lord. My lord, may kindly, my
Vacation,
lord,
summer vacation,
no, no, my lord, before the wave vacation, my lord,
leave vacation,
my lord.
the first week of June.
My lord, kindly
2029.
appreciate, my lord, otherwise I would not have pressed, my lord, the entire community is suffering, my lord, that's the reason, my lord. Kindly, my lord.
Special Marriage Act is already there. You
No,
can.
no, we cannot take records of that, my lord, there is also a religious bar, my lord. Will satisfy, my lord. My lord.
There can't be a religious bar against the
No, no, my
laws.
lord, the provision of the Special Marriage Act, we have gone through, my lord, but in that there is a restriction and limitation for applying under that act, my lord.
For whom?
For the Muslims, my lord.
In Special Marriage Act?
Yes, yes, my lord.
Which is that restriction, sir?
My lord,
Everybody, every community, every
No, every,
person
huh?
following
Maher,
any faith
my lord, lots of issues are there, Maher, Nikah, and everything is required to be examined, my lord.
your the restriction from your you mean to say that your faith restriction
They really, my lord,
no restriction of law, but your religion prohibits or restricted it.
exactly, my lord. The religion prohibits as well as the, my lord, the rituals or the religious practice. Those are also not any specialized authority to examine that whether the nikah has been religiously perfectly solemnized or not. Exactly. Lengthy hearing lagi हुई
That is that argument may not be
No, my lord.
fought because in the Special Marriage Act, though Hindu Marriage Act, the Satpadi and all is required. In the Special Marriage Act, no, it is not required.
My lord, we are not on that whether a marriage is halal or not. Who will examine, my lord? The authority under the Special Marriage Act cannot examine, my lord. Whether the kalima or the, my lord, the other ritual, my lord.
Let us see with here.
My lord. Highly obliged. My lord, may I pray for a date, my lord? Okay.
Second week, but it-
My lord.
10th of June.
June. Highly obliged, lord.
For hearing, item 34.
Oh, that Punjab Haryana High Court judgment.
Yes, my lord. Yes. I'll just recapitulate, my lord. On the last occasion, when my lord was perusing Ramkishan Fauji, my lord, in the later part of the judgment, there was one judgment quoted by Punjab and Haryana High Court, where it was said, my lords, that
It's not a criminal.
it's not a criminal, it's a civil proceeding.
Yeah.
But my lords would remember, my lords, I had relied on a Punjab and Haryana judgment, my lords, which was by a larger bench, my lords, 3 judges, wherein it was said that it's a criminal proceeding. Now, my lords, I took out the judgment, my lords. It has been reversed by the Supreme Court, and the Supreme Court has held, my lords, that it is not maintainable. What has been held by the Punjab and Haryana High Court, that a habeas corpus matter would be a civil proceeding, has been dismissed by the Supreme Court. My lords, I'll place the judgment, my lords. Adishwar Jain, my lords. 2006 11 SCC 339. 2006 11 SCC 339.
Adeshwar Jain.
Adishwar Jain. So that went to the Supreme Court, my lords. This is the High Court matter.
Reverse.
Yes, it's been reversed, my lords.
Where is that?
That's, my lords, has been reported 2006 11 SCC 339. Just one paragraph would suffice, my lords. The paragraph number 3. And even otherwise, my lords, it cannot be gainsaid, my lords, that the High Court rules, our High Court rules, prohibits an intra-court appeal from a writ petition file seeking habeas corpus. The third paragraph, I'll read it out, my lord.
Yes.
On the aforementioned allegations, an order of detention was issued on 5/4/2005. The appellant moved for issuance of a writ of habeas corpus before the High Court of Judicature of Punjab and Haryana. The said writ petition was dismissed by an order dated so-and-so by a learned single judge. A letters patent appeal, consideredly, which was not maintainable, was filed there against, which was dismissed by reasons of the impugned judgment. So the Supreme Court has held, my lords, that the intra-court appeal,
So many were
when it's clearly said, my lord, it was not maintainable.
maintainable on the ground that it's.
That has been not discussed, but it has been said. Now, my lords,
I mean, merits there.
if my lord, to satisfy my lords, Ram Kishan Fauji, my lords, what I can understand from the judgment, my lords, and there's the Punjab and Haryana High Court by a 3 judges bench, my lords, which has clearly said, my lords, that habeas corpus would be a criminal, a court would be exercising criminal jurisdiction while deciding.
The later judgment.
It's a 3 judges, my lords.
Later judgment or?
Not later, prior, my lords. Prior to the division bench of the Punjab and Haryana, my lords. Adishwar Jain. Adishwar Jain in any case has been reversed by the Supreme Court.
That is reversed not on this point.
But it has been held, my lords, that the writ appeal was not maintainable, considerably not maintainable. Of course, my lords, the Honorable Supreme Court has not discussed it in so many words. But, if my lord takes up Ram Kishan Fauji after my lord, so.
This judgment, how this judgment, Supreme Court judgment will help concededly, which was not maintainable.
Yes. Because-
Concede किया है sir.
No, my lords,
Sir.
I'll satisfy my lords on that. My lords, in paragraphs 10, 11, and 12 of the High Court judgment, my lords, the division bench Adishwar Jain, there was a single point of maintainability that letters patent appeal won't be maintainable before the division bench against the judgment passed. Exercise.
Exercising episcopal.
Yes, yes. No, that was the single point of maintainability, my lords. That has been rejected by the Honorable Supreme Court, saying that it was not maintainable at all. So even
concededly, which was not maintainable.
Yes, conceded.
Concede ki the council has conceded as a maintainable to nahi tha.
Considerably not maintainable, my lord. It is how it is construed. In any case, my lord. In any case, my lord. My lord, may kindly take up the judgment of
Ramkishan Fauji.
my lord Ramkishan Fauji for a moment. Ramkishan Fauji. Para 42, according to me, is the ratio, my lord. Para 42.
Para 42.
Now, my lord, the issue in Ramkishan Fauji was, my lords, that the letters patent 42. Now, my lords, the issue before Ramkishan Fauji was, my lords, that the letters patent, my lords, which was applicable to that particular high court, did not provide for, my lords, I'm so sorry, my lords. I'm so sorry. I'm so sorry, my lord. Paragraph 42, my lord. 42.1 to be precise. Yes.
Read para 41 se start.
Yes, yes. We have referred to these decisions only to highlight that it is
Just a minute.
I can provide a copy, my lord. Ramkishan Fauji. List of book this is Ram. I have given a list of books, my lord. It is there, my lord.
Yes.
Yes, my lord. I'll start from 41, my lord. We have referred to these decisions only to highlight that it is beyond any shadow of doubt that the order of the civil court can only be challenged under Article 227 of the Constitution of India, and from such challenge, no intra-court appeal would lie in other cases. It will depend upon the factors as have been enumerated therein. At this stage, it is extremely necessary to cull out the conclusions which are deductible from the aforesaid pronouncements. They are 42.1. An appeal shall lie from the judgment of a single judge to a division bench of the High Court if it is so permitted within the ambit and sweep of letters patent. Now, I'll pause here for a moment, my lord. So in place of letters patent, we have to read in the Guwahati High Court rules, since letters patent is not applicable. Now, what I understand from this paragraph, my lords, it is within the ambit of the letters patent. If it allows an intra-court appeal, it will be maintainable. If the letters patent does not allow, it won't be maintainable. In the instant case, the letters patent, provided that criminal matters, there cannot be any intra-court appeal. Now, in any case, the Honorable Supreme Court has held that it will be in terms of the rules. If the rules provides for it, you can file an intra-court appeal. There has to be some enabling provision, my lord, for letters patent appeal. Now, if my lords kindly take up the High Court rules for a moment. I'll trouble my lords once again, my lord, just for a moment, my lord. Now, my lords may first take up chapter 5A of the High Court rules. Chapter 5A of our High Court rules provides for appeals to the division bench.
Yeah.
Yes. Now, if my lords reads the That's the starting rules governing application for directions, orders or writs, bracket, other than in the nature of habeas corpus under Article 226 of the Constitution of India. So these rules, 5A, provides for the rules pertaining to writ petitions except a writ petition filed under habeas corpus. Now, my lords would come to 2, subclause 2. An appeal from the judgment and order of a single judge disposing of an application shall lie to a division bench if preferred within 30 days of such judgment and order. The division bench may condone the delay in filing any appeal if good or sufficient cause is shown. So an intra-court appeal would lie from all writ petitions except in writ petition filed for habeas corpus. Now, if my lords take up appendix chapter 11 for a moment, my lords, kindly, my lords, criminal business. Chapter 11, kindly.
1. Huh? Read 2.
Yes, yes. I'll again read 2-1. Yes, I'll just a moment. 2-1. Yes. Every such application shall be made and heard before single judge except where the Chief Justice otherwise directs, provided such an application falling within any one or more of the following categories shall be heard by a division bench except where the Chief Justice otherwise directs. Now, this provides for matters where the matters would be listed. At that point of time, when we had filed
That you have already.
Yes, yes.
Notification.
Single bench had the jurisdiction to take up habeas corpus matter. Now, my lord would come to chapter 11 of the High Court rules.
Oh.
Criminal business. Now, I have to show, my lords, that I'm so sorry. Chapter 11, my lords. Starts with the heading criminal business.
Yes.
Now, my lord, if my lord peruses chapter 11, which starts with the heading criminal business, my lord may peruse 39A and 43. This would show, my lord, that our High Court rules envisages a habeas corpus application as criminal business. There cannot be any doubt in that, my lord. Chapter 11, my lord. Clauses 39A and 43.
Yep.
My lord would read the headings first. Criminal business.
39A.
And 43.
Yeah.
39A, in habeas corpus matters, government advocate shall be notified even when such matters are placed before the court before preliminary hearing. Applications for writ in the nature of habeas corpus referred to in Article 2261 of the Constitution shall be governed by rules 30 to 42 of this chapter. So habeas corpus, chapter 5A will not govern habeas corpus applications. Rules 30 to 42 would govern
In
an
habeas
application.
corpus shall be notified 39A.
And 43, my lords, 43.
And applications.
In writs of habeas corpus.
So Article 220 shall be governed by 32 chapter.
Of this chapter. So, my lords, unlike chapter 5A, chapter 11 would govern, chapter 11, which provides that it's a criminal business, it would govern how an habeas corpus application will be dealt with.
We have to read all these, in isolation, we can't read this chapter 11 provisions and chapter 5 provisions.
Yes, yes.
Can't read in isolation, sir.
No, my lords, 30 to 42 of the same, my lords.
That's
how I can read from 30 to 42.
That we are reading.
Yes.
All applications under clause A, B, C, D, E. What
Yes.
is these are applications A, B, C, D, E.
Of 49.
The first information.
Exactly.
Exit charge. So and so. Order section code shall be made by an advocate. For the
Our High Court. No, no. It's 32 to 40 application. 32.
Yes.
My lord, may thereafter peruse appendix 32, my lord, which would lend some support to my contention, my lord. Uniform nomenclature of cases. It may be 34 in my lord's book, my lord. In my book, it is appendix 32. The title is Uniform Nomenclature. Uniform Nomenclature of Cases.
470.
My lord has it. Now, if my lord sees, my lord, A is civil proceedings. So civil proceedings, clauses 17 and 18, a writ petition under 226 and 227 of the Constitution of India, and 18, writ appeal. So civil proceedings provide for a writ petition, writ appeal. Now, my lords would come to criminal proceedings, my lord, which starts from serial number 71. So, my lord, 79 provides for WPC criminal, petition under Article 226 for writ and habeas corpus and other relief.
Yes, nomenclature will not govern the
So, my lord,
nature of the case.
what I-
Nomenclature we may give one.
So what I was on, my lord.
It's not the crux of the matter essentially is
In terms of, my lord, with all due respect, my lord, in terms of paragraph 42(1)(2) of Ramkishan Fauji,
Yeah.
what I have understood, my lord, it is the rules which would govern whether an intra-court appeal would lie or not.
Sir, intra-court appeal would lie. Now come to this chapter 5.
My lord.
What it says. This 2:1.
2:1.
Every application shall be made and heard before the single judge except the chief justice otherwise that.
It is only with, yes, sorry, my lord.
We
Sorry, my lord. I'm so sorry.
provided that such application falling within any of the more of the following categories shall be heard by the division bench except where the chief justice otherwise done.
Yes.
These are the 4 categories.
Right, my lord. Right.
PIL, habeas corpus, application relating to externment and deportation, any application which the learned single judge may refer to the chief justice for placing it before the having so and so.
Yes.
Writ petitions which constitutes a validity of the act and the rules of any provision thereof have been challenged.
Right, my lord.
Okay.
Right, my lord.
An appeal from the judgment and order of a single judge disposing on an application shall lie to the division.
Yes. Yes.
So,
Yes.
consciously,
Yes.
though normally it is to be heard by the division bench, but
Yes.
if the single, if the chief justice has directed that be listed before the single judge, and an application is disposed of by the single judge,
Yes.
then appeal would lie.
Yes. So, my lord,
The plain and simple, sir. Then as per this subsection 2, appeal would lie.
Yes.
Sub rule 2 of rule 2
My lord,
would lie.
with the deepest respect, my lord, what I have construed from 5A, my lord, insofar as clause 2(1) is concerned, my lord, that is only concerned with the quorum. What will be the quorum or the strength of the judges? Now,
Once
except
the
this, my
quorum,
lord,
the chief justice has said that a quorum would be of one judge.
one judge or
For hearing a particular petition,
yes,
any order passed by this single judge, by
Yes.
exercising, the
Yes.
appeal would lie, sir.
So, my lord, in that case, my lord, with the deepest respect, my lord, the heading clearly says it excludes a writ of habeas corpus, and thereafter chapter 11 again.
Rules governing, then where is the need of this habeas corpus application in rule 2, sir?
Yes, yes. Rule 2 only because of the quorum, my lords, because how habeas corpus has to be dealt with is provided in chapter 11.
Very much in the
Criminal petition. And our High Court has also decided, my lords, criminal matters, division bench, my lords, I have provided it the last day.
It's not a
Criminal matters won't go before the...
Essentially, it can't be treated as a criminal matter only because the procedure this applicable in the criminal matters is also made applicable to the this habeas corpus petition. That doesn't mean that it essentially it's a criminal matter.
Exactly. My lord, I was anticipating that my lord, contention, my lord. But in our case, my lord, since the rules are very clear, my lord, we need not separate the wheat from the chaff, my lord, because this judgment, my lord, Ramkishan Fauji clearly says it is the rules unless and until it is amended. A writ appeal won't.
This
now
chapter 5A.
Chapter 5A plus chapter 11 plus the nomenclature.
nomenclature.
The intention of the rulemaking authority is very clear, my lord.
We may give any nomenclature to any kind of petition. The nature of the this petition would not be changed.
My lord,
But nature is-
chapter 11 deals specifically with criminal matters. Chapter 11. I'm correct, my lord. Chapter 11.
Okay, we'll consider it. Yes. Now come on, merits.
My lord, can I place one more judgment that Punjab, Haryana, 3 judges, my lord, which says habeas corpus is a criminal. I have placed it on the last occasion. I'll just, it must be on the, it's my lord, the assessing authority versus Mansaram.
Yes, it is there. Yeah,
Yes, my lord.
64.
Yes, 3 judges, my lord. Before, my lord, it's
This is not of Punjab and Haryana, sir. I think so this is Supreme Court judgment.
this is full bench Supreme Court application. Yes, this is Supreme Court now.
What is this? This judgment is
I'm lucky then, my lord.
Punjab, Haryana or Supreme Court?
Indian law report, my lord, says Supreme Court application number 92 of 1964. My lord would come to the 3rd paragraph. Before, it starts with before. However, paragraphs are not
Before,
marked.
however.
Yes, my lord. I'll read, my lord.
Yeah.
Before, however, I do that, it is, I think, necessary to consider the rules framed by our High Court for dealing with such matters. These rules concerning writ petitions under Article 226 of the Constitution are contained in Volume 5, Chapter 5 in our case, Chapter 4F of the Rules and Orders of the High Court, and they fall into 2 parts. First part is FA and contains rules for writ of habeas corpus under Article 226 of the Constitution, read with Criminal Procedure Code 491, and they indicate the manner in which the court should proceed with such applications. I'll pause here for a moment, my lord. Chapter 11 is precisely pari materia, my lord. It deals with 491 and it says how a habeas corpus has to be dealt with. The second part, called FB, is titled Civil and contains rules dealing with writs of mandamus, prohibition, quo warranto, and certiorari, and for other directions. Applications for writ of habeas corpus are criminal proceedings without any doubt and are consequently separately provided by the rules. In our case, also separately provided by the rules. All other petitions under Article 226 are provided in the second part called Civil. The 2 sets of rules are not identical for obvious reasons. It would therefore appear that as far as the rules of this High Court are concerned, petitions under Article 226 of the Constitution of India fall into 2 categories, namely habeas corpus petitions, which are criminal proceedings, and other petitions for certiorari, etc., which are civil proceedings. As far as this court is concerned, therefore, I should think the rules are sufficiently clear on the point that writ petitions are either criminal proceedings if they're brought for a writ of habeas corpus, or if they're civil proceedings if brought with the object of obtaining other writ or directions. As I have said, the procedure for each category is separately mentioned. In fact, the High Court, my lords, our High Court, is exactly similar, my lords. Here, my lords, the Chapter 11 provides how a habeas corpus petition has to be dealt with. The nomenclature is criminal. 5A, according to me, my lords, with all due respect, says no intra-court appeal from an application for
First of all, please clarify, this is the Supreme Court judgment or Punjab and Haryana High Court?
My lord, yeah, this is SCC online. On the last occasion, my lord was convinced when when my lord produced this judgment, but my lord has seen that Adishwar Jain again. That's why my lord. Adishwar Jain is reversed.
There is no question of convinced. I was not convinced. That's why only.
Adishwar Jain was reversed.
Otherwise, we would have decided it immediately.
Adishwar Jain was reversed. That
Questions are fact,
491 is perhaps the earlier CRPC before 73. The rules were not amended. None, even now, the rules are the High Court. And my lord has also seen the Guwahati High Court Division Bench judgment, my lord, by Honorable Justice Mehta, my lord. It clearly says, my lord, it won't be maintainable.
That's in another context, not in.
Not in habeas, it says criminal matters.
Connection with the
Criminal matters.
habeas corpus.
Criminal matters won't be maintainable. Division.
Ultimately, it's a criminal matter. What is, yes, in some way we can say it's a criminal matter, but essentially it's not a criminal matter. Illegal detention.
Exactly.
Nothing violation of CRPC or something, nothing.
Exactly.
Only, detention.
I agree with my lord. I totally agree.
This habeas corpus is prerogative.
Yes, I totally agree. On that point, my lords, I totally agree with my lords, but the only difficulty is, my lord, with the deepest respect, my lords, the rules provides, my lords.
Okay, we'll decide it, but I would like to hear your merits also.
My lords, merit, I have not prepared myself very properly.
Oh, please, don't say that.
I thought, my lord,
What is the material before the
yes,
before
that
the
I have.
court to come to a conclusion that
Exactly.
gave the compensation of 10 lakhs?
Yes.
Why not 15 lakhs? Why not 8 lakhs? Why not 7 lakhs?
Yeah. My lord, in matters pertaining to habeas corpus where compensation has been awarded, the classic case is Rudul Shah's case, my lords. In none of the cases, my lords, there is any computation method, my lords, how they have computed.
That's why I only said, ultimately, if we come to a particular, a definite amount,
yeah,
there must be some justification. In the facts and circumstances of the case, then why not 15 lakhs? You could have challenged to tomorrow order case away 10 lakhs, so it's not adequate. Give me 15 lakhs or 20 lakhs or that's the whole thing.
Perhaps because
Prepare on that point.
Yes, ma'am.
Now we have heard enough on the point of
My lord has rejected the maintainability issue, my lord.
Sir, we'll decide it. If we find it that it is not maintainable, we'll dismiss it on ground of maintainability. But if once we found, then we don't want to put the matter for another day.
Okay.
We'll hear on merits. So
I'll be prepared on merits as well, my lord.
come prepared on merits. Sir, 10 days.
Item 35.
I'll give a date, man, for next date. Deeply obliged, man.
What's in item 35, I was directed to produce the inquiry report. What's in, may I place that report through a filing affidavit too? Otherwise, I have the inquiry conducted by the inspector. Lord. The report is sent by the department through email. Lord.
Okay. Next week.
Lord.
My lord, a copy of affidavit may be.
Definitely, he has to supply. If he is filing an affidavit in the court, he has to supply. Yes.
Passover meter 26.
Lordship, I'll file my written argument, just one day accommodation, Lordship. Yes, some citations are there, so I would like to place. So I don't have.
What relief you are seeking, sir? What relief you are seeking?
Lordship, one day accommodation. I'll.
But ultimately, we'll grant you the time.
Lordship,
What
this,
relief you are seeking?
that is the fact that the people of the
As to
Bodak Valley.
why the writ of nature or matter other appropriate direction like nature shall not be directing the respondent number one not to mix up ethnic entity of the Muslims of Assam with religious identity. Where is the question of mixing up this ethnic identity and religious identity? They have simply said the term used by them is indigenous Muslim community of Assam. So what's the
And my others
if
they
they
are
are
also
going
there.
to identify that those persons,
This.
how it is violative of which of the constitutional provisions, sir?
It is one of my
Directing the respondent not to conduct proposed socio-economic survey of 5 Muslim subgroups to uplift their socio-economic status on the basis of the religion. Sir, how such type of prayers we can grant? You are asking not to conduct a survey for uplifting of socio-economic status.
particular religious communities.
Sir, religious community is altogether different. These are the persons the government find that yes,
And
these persons are
above all, Lordship, if the prayer,
purely a policy matter. Assessment. That is also there. They have clarified.
survey and assessment, it may be typological error, but meaning is same, Lordship.
No. In fact, you come with a specific case that it was a survey. Then they said, okay, no, it was not a survey.
Assessment.
In the counter, they have filed this and not by the cabinet subcommittee. It was by a committee.
Constituted by the government. These are the just technical error, Lordship.
Adjourn. Yes. Okay.